The fundamental perspective that we bring to the debate is really that of the person whose rights or responsibilities are being affected by the tribunal. And I put to others the task of defending the tribunal and the way in which it has to operate in order to achieve its maximum performance. But I think there is a common ground that a balance must be struck here. There has to be some ability, particularly of a highly policy-oriented tribunal, to formulate rules of general application, to put at the disposal of that task the accumulated experience of all the members, and no doubt that policy is made having regard to real-life fact situations and not in a vacuum. But there is, whether we like it or not, a fairly healthy level of skepticism about the way in which many tribunals operate, and there is a satisfaction that people have of confronting the individuals who are making a decision that will affect their rights. And there is clearly an interest in coming eyeball to eyeball, whether one is discussing legislative policy or law, or pure social policy or economic policy or anything else. There is a sense that to have a fair airing of the matter, there should be some confrontation between the person being regulated and the decision maker that goes back to the notion of he who decides or she who decides must hear. And the fundamental distinction we make in the paper, which is at the root of all of this, is whether the traditional legal division between legislative functions and administrative functions is, first of all, a valid distinction, and secondly, if it is it properly observed in the cases before the Supreme Court in those that flow from it. The legislative function, of course, is always presented an anomaly in the law, because not only is it spread much more broadly than what we would consider as legislative organs, but that the general rules governing procedural decision-making and the protection of individual rights are largely waived. And of course, cases going back to Hailsham and the Inuit to Pirasat in the Supreme Court in this country review the necessity of the rules of natural justice being interpreted in a minimalist kind of way, dealing with natural justice. And the theory, of course, is perfectly straightforward, that what is at issue in the legislative function is not the individual rights of people, but broad legislative policy. And therefore, individual interests have no particular right to be heard. On the other hand, when you move across the Martineau spectrum to the adjudicative body, where the disposition is tied to the facts and of a particular dispute, then natural justice descends in greater rigor depending on the particular circumstances. For my purpose, the only decision or the distinction that is of importance is to keep in mind that there is a traditional gulf between the legislative and the adjudicative, symbolized initially by a separation of function between the legislature and the courts. That, of course, became increasingly blurred as administrative tribunals developed, and the functional separation was abandoned, and within a particular tribunal there would be some adjudicative function and some legislative function. And this was recognized as implicit in the mandate which the administrative tribunals had to perform. And in those tribunals that exercised both adjudicative and policy-making function, there were attempts to segregate out the hearing and the responsibility so that, again, as in the Cloverdale case, the court says when you are hearing the evidence and making findings of fact and assessing the particular circumstances of the parties, you're in an adjudicative mode and you have to observe the rules of natural justice. When it comes time to make your decision, then you are released from the full burden of a hearing and a court-like setting, and in the formulation of policy, you spread your wings and the courts will be loath to interfere. As I see it, the problem posed by Consolidated Bathurst and Tremblay and the cases that have followed it is that there is now a mixing of the adjudicative and the legislative function or policy-making function, not only because it's done by the same body, but that it's done in a mixed-up kind of way where initially the panel hears the facts, makes a decision, a preliminary decision, if you will, about the particular interests before it. The body then, in the case of Tremblay, makes a draft decision. It then goes into a broader forum where all of the members on the panel have a chance to put in their 2 cents worth as to what the appropriate policy should be. It then contracts back into the hands of the panel that is actually adjudicating the dispute, and a decision is then rendered. So that instead of there being some kind of conceptual distinction between the hearing by the adjudicators and the application of policy by the adjudicators, there's the hearing by the adjudicators, application of policy, then the introduction of people who haven't heard the evidence, and then it goes back into the hands of the panel, and then they come out with a decision. And it is, in my view, that clearly raises serious problems looked at from the orthodox administrative law perspective. Because if one looks at the 2 branches of natural justice, the opportunity to be heard and bias, the first problem that is raised is clearly that the people who are adjudicating your rights may have been biased by discussion with others who have not heard the evidence and who may not be familiar with the particular circumstances, and that indeed your rights are being judged not by those seized of your particular problem, but they will have their free will, in effect, forced by the views of others on the full board. With respect to the opportunity to be heard, the party is obviously confronted in the case of Tremblay, where there's a reversal of the decision of the adjudicators based on this full board proceeding, and what has transpired in the full board is not disclosed, and one gets into problems of deliberative confidentiality surrounding the panel. But somehow what has emerged at the far end of the process is a decision that contains many elements that you as a party have not had an opportunity to address. Now, as I understand the decision in Consolidated Bathurst, and our discussion of it starts at page 8 of the paper, the Supreme Court essentially accepted that in the adjudicative model of the Ontario Labour Relations Board, there had to be a functional separation. In other words, the court was not saying that the rules applicable to adjudicators of lack of bias and the opportunity to be heard and so on should not apply, but that in the particular circumstances, the Ontario Labour Relations Board had succeeded in keeping those functions separate. And it's important to understand the particular facts of Consolidated Bathurst because of what comes later. In that case, the policy before the board was whether an employer had failed to bargain in good faith when in the course of collective bargaining negotiations it had failed to disclose to the union what the board found was a de facto decision to shut a plant. So it went to legitimate concerns about protecting the collective bargaining process and matters of policy in the fostering of good labor relations. The board had previous cases dealing with that kind of issue. A preliminary decision was made, and a member of the adjudicative panel said, this is a policy of broad import, let's bring in other members of the board. So there was a voluntary gathering of the troops from every corner of the Labor Relations Board. They were given the facts of Consolidated Bathurst. It was made clear that they had no mandate to affect the facts as found, and they were restricted to a freewheeling policy discussion about the nature of collective bargaining and the appropriate rules of candor. It was made clear to the adjudicators who had asked for the full board consideration that they were in no way constrained by the discussion, and that the full board was to avoid consideration of issues that had not been presented to the adjudicators. So that in theory, the adjudicators were simply consulting in an informal way, in a way that the Supreme Court found similar to judges talking amongst themselves about particular issues of law. And the Supreme Court held that in the absence of constraint on the adjudicators and in the absence of new grounds to which the parties would otherwise have a right or an opportunity to address, the decision, or the interference, if you will, or the participation of the full board did not invalidate the decision. Tremblay in Quebec, which we start talking about at page 15, is the flip side, where clearly there was interference by the full board, in this case the Commission des Affaires Sociales, in what the adjudicators left to their own would do. There was a claim by Tremblay for reimbursement of certain medical expenses, and a draft decision was produced by the adjudicators saying Tremblay is entitled. There was an internal procedure whereby decisions of the Commission went to the lawyer for the Commission just to check for legal issues. The lawyer was on holiday, so it went to the president of the Commission, who said this decision is wrong, and wrote a memorandum to that effect. The full Commission was then summoned, and it was a compulsory appearance, and a vote was taken as to what the policy should be. And not surprisingly, a majority of the Commission decided to support its president, as a result of which the decision was changed, and Tremblay lost. So clearly there was bias in that the adjudicators had their minds made up for them by the full Commission, and there were considerations arising in that full hearing that were never notified to the parties. So the Supreme Court said this is quite different from Consolidated Bathurst. Here there is constraint, there are votes, there are minutes, and the decision is bad. Now, what I take out of the Supreme Court, those two Supreme Court decisions, is firstly an intention to stick with the rules of natural justice in their application to institutional decision-making. And that while the procedure may blur the distinctions conceptually, in practice the distinctions are observed. And it is this underlying factual basis that it seems to me has been lost in subsequent decisions, because both Tremblay and Consolidated Bathurst are highly fact-driven. Just exactly how is it that those full board hearings were run? Why were they invoked? Were they asked for by the adjudicators, or were they imposed on the adjudicators? Were the adjudicators under a constraint, or was it simply the influence of the discussion, and so on? So Consolidated Bathurst and Tremblay, on the face of it, does not revolutionize legal orthodoxy. What it does is that it makes very fact-specific exceptions. From that point on, however, it seems to me there has been a descent into the abyss, because the courts now seem to feel that something called institutional decision-making is okay. And not only have they abandoned the inquiry into what exactly went on at the full board so that the court can be satisfied that the rules were observed, but there's also now been put on to the applicants for judicial review, in effect, an onus to demonstrate improper consultation. The Supreme Court decisions, while they attempt to be fact-driven, set up this huge problem about deliberative secrecy. I mean, to what extent does the Supreme Court legitimize dragging out of a tribunal all of the circumstances surrounding the making of a particular decision? But on the other hand, if they're not prepared to do that for perfectly understandable reasons of public policy, why should the applicant whose rights have been caught up in this full board proceeding be asked to assume that everything was done to protect his or its or her rights? In other words, the fact-driven approach by the Supreme Court, it seems to me, runs smack into the public policy favoring deliberative secrecy, and the Supreme Court has really not come to terms with how the exceptional rule in Consolidated Bathurst and Tremblay can be effectively run. At page 22 in the paper, we start getting into the progeny of Consolidated Bathurst and Tremblay. The Con in the College of Physicians and Surgeons is discussed, particularly in light of the lack of information in the record that would enable a court to say the rules were upheld. As it says at the top of page 23, the court really reversed the onus and said, well, there's nothing in the record to suggest constraint. Now, what that, it seems to me, leads to is the extent to which the community of people affected by regulatory decisions are prepared to suspend any sense of disbelief that their rights have been affected in ways not sanctioned by the rules of natural justice, even a diluted application of those rules having regard to the nature of the decision. In the Glengarry Hospital case, at page 24, there were a series of consultations by the Vice Chair of the Pay Equity Hearings Tribunal, and there was really no evidence before the divisional court, according to the report of the case, as to the particulars of those consultations and whether they complied with the directions of Consolidated Bathurst, or the absence of constraint the absence of new grounds for decision, and so on. Now that, again, it seems to me, shows where the Supreme Court and reality come into collision by saying constraint is offside. You cannot have adjudicators constrained by a full board hearing, but influence is acceptable. There's no reason why the adjudicators cannot be influenced by what went on, and indeed that is the whole purpose of a full board hearing, to achieve consistency in the policy being adopted. So, as you move from Glengarry Hospital through the other cases we refer to until you hit the grandfather of all institutional decision makers, the Immigration and Refugee Board. And we find decisions of the Federal Court of Canada, which are referred to at pages 28 through 30, where the court has been prepared to accept that this label, institutional decision maker, now stands for an okay concept, and that it is not necessary to go behind the label and to determine exactly how the decision-making process was conducted, either in that particular case or generally. My perspective on the result of all of these cases is really as follows. I believe that the Supreme Court has created problems by offsetting deliberative secrecy with the notion that the full board proceeding can be sanctioned if the court is satisfied that it did not breach the applicable rules. In my view, the dividing line between constraint and influence is really an unenforceable guiding line. But thirdly, and perhaps most importantly, what seems to be left out of the equation here is not only the institutional needs of the tribunal to take advantage of accumulated expertise and so on, but the appearance to the applicant or the respondent that the decision was properly made. And as is set out in our paper, our recommendation is that a more easily policeable regime is installed so that people dealing with these tribunals can have some satisfaction that they have been dealt with fairly, and that this could be accommodated in a way that does not interfere with proper institutional decision making. I think McCruer in his report suggested that if there are to be these full board hearings, then the counsel for the parties ought to be present and be invited to address matters which they believe affect the particular interest of the client. This may be an undue wet blanket on the candor of discussion at the full board hearing, but it seems to me that there would be no legitimate complaint to having some kind of record kept of the full board hearing on a not for attribution basis, so that the parties could have some idea of the matters being discussed, and then given the opportunity to make submissions on those, if appropriate, before the adjudication is handed down. Having said all of that, the tedious detail is set out at length in the paper. And Mr. Chairman, if there are any questions in the short time that remains before I flee, I would be glad to take a stab at answering them.
I have 13 after. Does that give you enough time to answer questions if there are any?
Generally, there aren't any, so that's why it's an empty offer.
Why don't we assume there aren't any? And we'll take all of the questions aimed at you for the panel that follows you.
Excellent.
Thank you very much.
Thanks a lot, very much.
Well, we're on time with one. I'm going to invite up the panel that's commenting on Ian's paper. It's Ron Ellis, Bryan Finlay, and Joan Smart. While they're coming up, I'll reiterate the announcements that the Law Society wanted me to make when not all of you were here. The first was that the Law Society would like you to fill out your evaluation for this morning. The second was that the Law Society would like you to fill out your evaluation for this afternoon. You'll notice that there's an evaluation form in each of the books. Quite frankly, I don't care if you put them together, but I think the Law Society may. And the third comment is that the papers that for this afternoon's program that are not currently in the volume, those of Ron Ellis, Joan Smart, and Mr. Justice Laskin, will be sent to you when they are received, and we're expecting to receive them soon. And in fact, I just blew it, Joan's is here. You can pick up Joan Smart's paper outside during the coffee break, and the other two will be sent to you afterward. That brings us to a panel discussion on institutional decision-making. We have on the panel two administrators or regulators and one practicing lawyer. Ron Ellis is chair of the Workers' Compensation Appeals Tribunal. Bryan Finlay is a barrister with Weir and Folds, and in fact, he and I were co-counsel on the Ainsley case, for which I got too much credit this morning. Bryan deserves at least as much. And Lord Hewitt would still turn over in his grave at Bill 190. And Joan Smart is vice chair of the Ontario Securities Commission. What we're going to do is we're going to have short presentations, and then we'll open it up to discussion. I think the panelists want to talk to each other, and you may want to talk to them. And I'll follow through in the order in the program and invite Ron Ellis to talk to you. Ron's more formal than I am.
Morning, afternoon, ladies and gentlemen. At work. In studying Mr. Binnie's paper in preparation for this panel, I was struck once more with the range of the terminology which legal authorities have classically used in attempting to describe and distinguish what administrative justice system agencies do, and with how unhelpful much of that terminology seems to be in the consideration of appropriate limits to institutional decision-making. The terminology one finds in the authorities respecting what agencies do, as cited, for example, in the opening pages of Mr. Binnie's paper, include the following range of labels: a policy-making role versus an adjudicative role, policy contrasted with facts and law, legislative decision-making contrasted with adjudicative decision-making, with the latter characterized as the judicial function, and the former seen to encompass rulemaking or generalized rulemaking. Rulemaking as a form of policy-making or legislation, and distinguished from adjudication. Then there are administrative decisions and administrative policies and administrative functions, which have been referred to as policy interpretation functions, and which are to be distinguished from judicial functions. Mr. Binnie himself refers to the hybrid functions of Canadian administrative tribunals, which are, he suggests, on the one hand, a policy creation role, referred to as a legislative, and on the other, a policy application role referred to as adjudicative. This is the classic terminology, but for me, none of it seems to help much with Mr. Binnie's question, did the court get it right in Consolidated Bathurst? Is there, I wondered, a more basic description of what agencies do that would be more relevant to this issue? And that question set me off on an exercise of trying to reduce what agencies do to their essential components. And I found that exercise surprisingly interesting. And I'm taking the liberty of sharing the results this afternoon in the perhaps optimistic hope that members of this audience might find it of some interest as well. Maybe that you'll all find it only irritating, but I'm hopeful. What follows is still something of a work in progress, but contemplation of an old problem dressed up in fresh terminology should be at least stimulating, and perhaps it may serve to provoke some lateral thinking on the part of others. What has occurred to me is that it is useful to notice that both courts and agencies, be they so-called regulatory agencies or adjudicative agencies, really perform only two basic functions. They make findings and they formulate opinions. By findings, I mean conclusions that are based on evidence and at which, at least in the context of an adjudication of a particular litigant's rights, are governed by technical rules respecting admissibility of evidence and standards of proof and burdens of proof. Findings also typically involve the resolution of issues of credibility. Opinions, on the other hand, as I propose the term to be used, are most importantly distinguished by the fact that unlike findings, they do not have to be substantiated by evidence in the technical sense of that term. Of course, in both agency and court settings, opinions do not remain merely opinions. When formulated in a settled way, they have an operational effect. And in an adjudication context, we call them decisions, or see them as part of the reasons for decisions. I wonder if I could trouble the chair for a glass of water.
Be glad to.
The nature of the operational effect of an agency's or court's opinions depend on their status. Opinions can be authoritative or merely persuasive, and in the latter case, to varying degrees of weight. Thank you. Opinions reached through a process of adjudication have an authoritative status as far as the parties to the adjudication are concerned. For other parties, in subsequent cases involving like questions and like findings, such opinions will be either authoritative or merely persuasive, depending on the level of the agency or tribunal whose opinion it is, and how the rules of precedent work in application to the opinion in that particular context. Opinions reached in an agency's non-adjudicative, generic rulemaking processes and published as agency policy or guidelines typically are not conclusively authoritative, having regard to the no fettering principle, but only strongly persuasive. Whereas such opinions published as regulations under regulation-making powers are thereby, of course, given authoritative status. The opinions formulated by agencies and courts fall, in my submission, into four subcategories. And these I have called issue agenda opinions, interpretation opinions, regulatory opinions, and application opinions. Issue agenda opinions is the label I'm suggesting for opinions about the list of questions the law requires an agency or court to answer given the findings. The questions the law requires to be answered given the findings themselves fall into two categories: legal questions and what, for lack of a better generic label, I have chosen to call regulatory questions. Regulatory questions are defined by the law but require answers which, while they may be influenced by findings, are wholly dependent ultimately on what, if it were not such a lofty word, I would call wisdom, but which instead I will settle for good judgment. The general form of those regulatory questions is very familiar. What they typically ask is, what is in the public interest? What is advisable? What is reasonable? What is fair? What is appropriate? What is necessary? What is significant? What is substantial? And so on. Interpretation opinions is the label I propose for opinions about what answers the law, be it statutory or common law, provides for the legal questions in the issue agenda. Regulatory opinions are opinions about the wisest answers to the regulatory questions in the issue agenda. And finally, I've given the name application opinions to opinions about what consequences logically must follow when settled interpretation opinions and regulatory opinions are applied to findings. I've included reference to these four subcategories only to show that the broad category of opinion is sufficient to encompass all that agencies or courts do other than make findings. Thus, in my view, any decision of any administrative justice system agency, whether it be a regulatory agency or an adjudicative agency, and whether it be an adjudicative decision in a particular lease between parties or a generic policy decision made through a rulemaking process, and any decision of any court, will be seen to be comprised explicitly or implicitly of findings, an issue agenda opinion, one or more interpretation opinions, probably one or more regulatory opinions, and an application opinion, and nothing more. For purposes of this debate, however, the four subcategories are an unnecessary complication. In addressing the consolidated Bathurst issue, it is sufficient, I think, to simply recognize that all that tribunals and courts do is encompassed in the categories of 1, making findings, and 2, formulating opinions. And now I propose to apply that bare-bones terminology to a brief consideration of Mr. Binnie's question as to where the balance is to be struck in the adjudication of particular conflicts between the rights of litigants and the needs of decision-making institutions. Mr. Binnie's paper and the jurisprudence so far identifies 2 categories of rights of litigants that are thought to be endangered by institutional decision-making devices approved under the consolidated Bathurst line of cases. One is the right to have their cases decided by an unbiased adjudicator, and the other is the right, through evidence and argument, to influence that adjudicator's decision-making. There can be no doubt that the right to an unbiased decision is unqualified and applicable with equal weight to opinions and to findings. Obviously, institutionalizing processes cannot be such as to constrain individual adjudicators from either making their findings or formulating their opinions in accordance with their own final views. There is also no dispute that the litigant's right to influence adjudicative decision-making is probably exclusive and comprehensive as far as the decision-making relates to findings. But when it comes to decision-making about opinions, the right to influence decision-making is, in my submission, necessarily and appropriately limited. And I would submit that this has always been the case in the civil justice system, and that the consolidated Bathurst jurisprudence has not introduced anything new in that respect. It has merely brought out of the closet, to use Mr. Binnie's phrase, limits that before were only implicit. It is apparent, is it not, that in the civil justice system, which is the point of reference for litigators critical of consolidated Bathurst, a litigant's right to influence adjudicators respecting their adjudicative opinions was never either exclusive or comprehensive. With respect to opinions, there have always been various sources of influence on their formulation beyond those offered by the litigants. And litigants have never had the right to know of those other opportunities or to have post-hearing opportunities to ameliorate their influence. The external sources of influence on adjudicators respecting matters of opinion to which litigants have traditionally never been privy may be seen to fall into 3 basic categories. First, post-hearing discoveries in the literature of the law, textbooks, academic articles, and other cases in the nature of persuasive or actual authority that were not presented by the litigants but were turned up post-hearing by adjudicators or their assistants' own research. 2, views of adjudicators' assistants, typically, for example, court clerks, and then, most importantly, collegial discussion with other members of the adjudicator's court, including Chief Justices and Associate Chief Justices. I would note particularly with respect to the influence of collegial discussions that it is the acknowledged legitimacy and importance of those very influences on matters of adjudicative opinion which have always been seen to require the limiting of appeal courts to small companies of judges so that such collegial discussion may be fostered. All that the civil justice system has ever accorded litigants in the way of opportunities to influence adjudicators in their decision-making respecting adjudicative opinions, with the single exception of issue agenda opinions, to which exception I shall return momentarily, is a full but one-time opportunity to persuade an adjudicator to the litigant's view of the proper opinion. That opportunity has included the freedom to find and attempt to ameliorate the possible sources of negative influence within the literature of the law, and to anticipate the arguments or views that an adjudicator may be expected to conjure up or to encounter in discussions with assistants and colleagues, and to make full arguments addressed to countering such arguments and views in advance. But it has not included a right to post-hearing access to the sources of influence which adjudicators encounter or seek out during the decision-making process respecting opinions. In short, litigant-free access for adjudicators to outside sources of non-constraining influence respecting opinions, which is all that Consolidated Bathurst approved for agency adjudicators, has always been implicitly available to courts and judges and cannot be challenged on the basis that it is an infringement of existing rights or traditional practice or expectations. As I mentioned, to this general proposition that adjudicators are entitled to litigant-free access to outside sources of influence respecting opinions, there is one notable exception, and I refer to issue agenda opinions. Issue agenda opinions do not figure largely in the work of the courts because of the authoritative role of pleadings in fixing issue agendas in court proceedings. But pleadings are not commonly a part of agency proceedings, and usually in those proceedings, the issue agenda ultimately reflects the agency's opinion as to the questions the law presents, given the findings. There will, of course, have been an issue agenda opinion that was operational during the course of any hearing. That opinion will have guided the litigants in their selection of evidence and in the arguments they would have made concerning the preferred findings and concerning the interpretation, regulatory, and application opinions that were required by that agenda. When an adjudicator has occasion to consider, post-hearing, changes to that opinion, then the right to a full and fair hearing seems to obviously require that the litigants be given an opportunity to make submissions concerning the proposed changes, and where the issue agenda opinion is changed, to then present further evidence and argument respecting the different findings and opinions the adjudicator will now have to consider in light of that change. This, in my submission, is the obligation to inform the parties of any new ground on which they have not had an opportunity to make representations, which Consolidated Bathurst identified as a requirement of any institutionalizing procedure and referred to at page 13 of Mr. Binnie's paper. Let me then, for just a brief moment, turn back to findings. As previously noted, the issues concerning litigant access to outside influences are different with respect to findings. The proposition that it is not legitimate for adjudicators to be influenced by outside sources respecting their findings, which in my view is the essence of the Consolidated Bathurst exclusion of factual matters from institutionalizing processes, is certainly straightforward with respect to findings based on evidence in the nature of testimony by non-expert witnesses at hearings. Whether it is equally straightforward when it comes to documentary evidence, or even perhaps expert testimony, may be a question for another day. In conclusion, may I come back to where I started, that it is useful in assessing the implications of consolidated Bathurst to move away from the traditional terminology, to reduce what agencies and courts do to their essentials. In my suggestion, making findings and formulating opinions, and to assess the damage that the consolidated Bathurst jurisprudence is alleged to be inflicting on traditional litigant rights in the light of that simplified construct. Thank you.
Thanks, Ron. Bryan?
Yes, I'd like to return really to what Mr. Binnie had to say about consolidated Bathurst and Tremblay, and his statement that from his point of view, both of those cases maintain the orthodoxy. I would take issue with that. I don't think there's any doubt but consolidated Bathurst and Tremblay signify a complete sea change with regard to the rights of parties appearing before tribunals, with regard to presenting their case to the party or to the tribunal that's got to hear it. We are now faced, and the case law subsequent to these two cases reflect, that more and more issues are being determined which are of substantial importance to the parties that are appearing before a particular panel by full board meetings or by some process, call it institutional decision making, at which the parties' counsel is not at the table. And I think that's clear and accepted. Secondly, I think we're going to see more and more of this. I think that the courts are prepared to give great deference to administrative tribunals. And I can't see any trend that's going to cut back against the use of institutional decision-making, being full board meetings or some other process. Now, what really is the issue for parties appearing before tribunals, and it always has been this since time immemorial, is to understand what the process is that is going to be followed by the tribunal in coming to a decision. And the great problem with Connie Bathurst and Tremblay is they put the onus on the party to create a prima facie case in order to allow the party to know what the procedure is that is being followed. Most of these cases, you only find out, you only get your foot in the door as counsel appearing before one of these tribunals by pure happen chance or luck. Perhaps one of the oldest, well, not the oldest case, but one of the old chestnuts is the Latimer case and the Ontario Securities Commission, a case that decided back in the early 70s. The only way that case got before the courts was because Jack Weir wrote a letter to a member of the Securities Commission and asked for some information. And the commissioner quite generously provided the information. And from that point on, the case was in the courts and on its way. And the courts, in the discussion, Latimer said, you know how this case all started? It was because one of the commissioners was good enough to answer a letter. Now, the problem with Connie Bathurst and Tremblay is that secrecy is imposed unless, on the deliberative process, unless counsel can somehow show there's some reason to question it. And in my submission, that's got to change. And it's either got to change by the courts changing it, or it's got to change by the legislature. There's, in my submission, I don't agree with Mr. Binnie's solution that we get to attend the full board meetings or that they keep minutes. First of all, if we get to attend the full board meetings, there won't be any full board meetings. Second, we all know that keeping minutes of meetings, especially when you know those minutes are going to be reviewed by third parties, can become an art form and really reflect little of substance. So I think there's no question but that the courts are going to have to change, or the legislature is going to have to change, and it's going to have to require tribunals to set out the process that's going to be followed. You appear before the tribunal is going to listen to it. It may then, in certain circumstances, go to a full board meeting, or it may engage policy aspects of the commission. It'll then go to a full board. It'll then come back to the commission. You'll appear before the commission if there's X, Y, and Z. That process has to be set out. And I would really, and I've got on either side of me members of commissions, I would really call upon commissions to publish what their process is. I remember that when you're appearing before a tribunal, you got to learn about the chemistry of that tribunal and what its process is. You go in to their waiting room and you pick up a pamphlet as to what the procedure is. Who is the secretary? You phone the secretary. You say, what happens? You ask questions. So I say to the tribunals, tell us what the process is. Secondly, I say this. If we're going to have these, and quite frankly, I believe that this sort of full board meeting or institutional decision-making is a good thing. I think if we're going to have it, and I set out in the back of my paper two steps, if you will, to making it work. One is to have full disclosure of the process. The second is, I would ask the panel that here's your case to write its draft decision before it engages the full board meeting or the institutional decision making. Have that panel draft a decision. Then have the full board meeting or whatever takes place take place. And if there's going to be any change to the decision, then have counsel advise what the change is and the reasons for it, so counsel can attend and address those reasons. No, I don't think there's any point in having us present at full board meetings or otherwise engaged in the process. But we must have the opportunity to address any changes and the reasons for those changes. These issues are of fundamental importance for us and for, especially for clients who appear before the tribunal. And I've listened to Ron speak about the different types of decision making that takes place and the different types of facts and issues that are determined. It is, when you're before a tribunal with an issue, it is almost impossible, as Mr. Justice Steinecke has said, to draw the line between where policy stops and facts begin. That's just something that is very, very difficult to do. I frankly think this is really a very, very critical issue in administrative law. In fact, probably, if not the most, certainly in the top 2 or 3 of the most important issues. And how people who appear before tribunals are going to be protected, as they have been since time immemorial in this new procedure, I think can be done. But we're going to have to get out from under the secrecy which the Supreme Court has imposed as a result of its decision in Tremblay and followed up in the Laskin case. I look forward to the questions.
Thank you, Bryan. Now we'll give another administrator a chance to respond to that if she wants to. Joan Smart.
I'll respond to Ian Binnie's paper first, and then I'll get back to Bryan with some questions. At least in recent years, the Ontario Securities Commission hasn't engaged in the kind of institutional decision-making that was done in Consolidated Bathurst. I think it's been for a couple of reasons. One, because of the administrative concerns that arise out of it. And secondly, because of the nature of the commission and the way it operates, we haven't felt the need for it. But certainly for a lot of administrative tribunals, having access to this kind of decision-making is important, particularly tribunals that have a large number of adjudicators and a heavy caseload. In Consolidated Bathurst, it was recognized that the meetings are important for a number of reasons. Firstly, to acquire the benefit of all of the tribunal members. Secondly, to develop more consistency in decision-making, and hopefully that would result in equal treatment of individuals that appear before it. Thirdly, increase the quality of the decisions, and hopefully lead to a better allocation of resources. But I think, as everybody recognizes, there are problems inherent in the process. And Ian has proposed a couple of solutions to those concerns. The first one was to allow the parties to attend the full board meeting, and Bryan may be right to some extent on that. In my view, it would be preferable to have a larger number of panel members participate in the entire hearing rather than go through that kind of a bifurcated process. Alternatively, Mr. Binnie has proposed that minutes be kept of the meetings. That may be a workable solution. I can also understand Bryan's concern about that. It doesn't address the apprehension that parties feel about something going on in their absence entirely. The thrust of my paper is that administrative tribunals would be wise to consider other means to achieve consistency and coherency in their decision-making, aside from adopting the Consolidated Bathurst type process. In the Tremblay case, I think the court really invited tribunals to do just that. This, looking at other alternatives, hopefully would reduce the number of occasions when a tribunal has to resort to the Consolidated Bathurst process. I don't think there's too much magic to these other alternatives. One obvious one is for the tribunal to develop a database of relevant decisions to which all members of the tribunal could easily have access. That could include their own decisions as well as other relevant decisions in related cases. Another tool would be for the tribunal to have regular meetings at which they could discuss recent developments. This could include developments in the law, developments in policy, as well as substantive developments. Also, tribunal members could meet subsequent to decisions being rendered in particular hearings to discuss the policy issues that came up in the course of the hearing. Then after those initial discussions with respect to developments or issues that come up in hearings, if the tribunal thought it appropriate, they could then work on developing a general policy in the area. I think counsel appearing before tribunals also have some responsibilities. First, to raise the policy issues squarely before the tribunal and assist the tribunal in ways that those policy issues can be dealt with. And secondly, to assist the tribunal in informing the tribunal of relevant precedents. The mechanism that the Ontario Securities Commission has used most extensively is policy making outside of the context of particular hearings. I think you heard a bit from Phil this morning on that if you were here. The OSC, as well as a number of other administrative tribunals, does have the authority to make policy as well as to adjudicate. I think this kind of policy making can achieve some of the objectives that were noted in Consolidated Bathurst, namely obtaining or achieving some consistency and coherency in decision making, and hopefully a better allocation of resources as well. When the tribunal formulates a policy outside of the context of a particular hearing, it also can obtain the benefit of comments from others in the industry that may have an interest or particular expertise in an area. The policy can serve to inform or indicate to interested parties in advance how the tribunal might exercise its discretion and how it might interpret its governing legislation. But as has been mentioned, a tribunal can't fetter its discretion in particular cases in doing that. So in the course of a particular hearing, a respondent would have an opportunity to say why that particular policy shouldn't apply to the particular case at hand, and the tribunal would have to be prepared to make exceptions to the general approach where that would be appropriate. But of course, policymaking outside of particular hearings can also have its difficulties. I suppose the first one is that it doesn't address an inconsistency in a particular decision, but hopefully it would address future decisions that might come down after the policy has been promulgated. Recently, the OSC has also discovered that promulgating a policy in advance of a particular hearing arising may give rise to allegations of bias. I'll just spend a few moments going into the particular case I'm referring to. I think probably everybody has heard about the Ainsley decision by now. What was behind that was OSC Policy 1.10, which the Commission had developed to address certain concerns it had about high pressure and other unfair sales practices that it saw being engaged in. In the policy, the Commission stated it's issuing this policy as a guide to identify what the Commission believes are appropriate business practices to assist securities dealers and their employees in satisfying their obligations under the Act in connection with the marketing and sale of penny stocks. This policy is intended to inform interested parties that the Commission will be guided by this policy in exercising its public interest jurisdiction under a particular section of the Act and its general public interest jurisdiction. And that led to the Ainsley case. Then several months later, I guess 7 months later, OSC staff issued a notice of hearing against a particular securities dealer by the name of E.A. Manning and several others. The hearing was to consider, amongst other things, whether Manning's registration as a securities dealer should be canceled. The OSC staff in the notice of hearing alleged that Manning had engaged in conduct involving trading in penny stocks, which was abusive of the capital markets and contrary to the public interest. And then there was a subsequent notice of hearing issued against Manning later on, several months later. Manning then brought an application for judicial review for an order in the nature of prohibition to prevent the Commission from hearing the cases against Manning on the basis that the entire OSC, or all of the commissioners, were biased against Manning. The divisional court dismissed Manning's applications. It concluded that 2 commissioners who were appointed subsequent to the promulgation of OSC Policy 1.10 were not biased and could form a quorum to hear the matter. But it also found that there was a reasonable apprehension of bias in relation to the commissioners who had been involved in developing OSC Policy 1.10. And in making that decision, the court stated that in the process of formulating and deciding to issue a mandatory regulation presented by Policy 1.10, the commissioners in March 1993 closed their minds to the issue of whether securities dealers, including Manning Limited, are guilty of unfair sales practice. This constitutes prejudgment. That case has subsequently been appealed by Manning to the divisional court, and to the Ontario Court of Appeal, and the decision is currently under reserve. But the case raises some interesting questions for an administrative tribunal that has both policy making and an adjudicative role, and questions about the interplay between those two. On the one hand, a tribunal may feel it's in the public interest to issue a policy dealing with a particular matter, and that in doing that, it's appropriate to state clearly, for purposes of transparency and public accountability, the reasons behind coming up with the policy. On the other hand, the tribunal may later find, when it is involved in a hearing where that policy comes up, that there may be an allegation of bias made against it. Now, this may well be an unusual case, but I think it does point out that in developing policies, tribunals have to be very careful to avoid crossing the line between having pre-knowledge about a particular issue and actually prejudging a future case. And I think, as has been pointed out today, the OSC has now embarked on a new era when we have rulemaking as well as policymaking and adjudicative role. That presumably will serve to increase the consistency in decision-making, while at the same time it will reduce to some extent the flexibility in the decision-making. I think we'll all be watching how the interplay between those various roles develops.
Thank you, Joan. Sure. Let's play free.
I have a question of Bryan, which is, if you had noticed before going to a hearing that the consolidated Bathurst type process was going to be followed, how would you approach the case differently?
I think I would approach it from the point of view that I would want to try to elicit what were the policy issues really that were of concern to the tribunal when I appeared before the panel. I'd be much more interested than I would be normally with what would be the broad policy issues at stake, which would be the discussion that would take place outside of my participation.
There are a few other things you might do as well. I might ask for a hearing before the full commission, if I knew that were going to happen, depending on its size. I might also invite the commission to adjourn my hearing on the adjudicative matter and engage in its policy making in advance, in a formal policy making process, so that by the time my client was before them, we knew what we were dealing with. I mean, there are a number of alternatives. Bryan's is one, there are others, and my guess is that if you were put to it, you'd sit down and think hard and might come up with a few more.
I think Phil has just indicated why this isn't about to happen anytime soon.
Well, Ron, you know.
Well, I'm glad I don't appear before some tribunals, Ron, but...
Well, I think that's a very informative response. We've only got a few minutes left, but really there, and I say this, you'd like to get above the partisanship that really takes place in so much of our appearances before tribunals and on these issues, but I think it's extremely important that both the bar and the tribunals come to a sense that we can develop systems that are going to work. The tribunals can't retreat back behind a fortress, and counsel can't be obstructionist. And somehow there's got to be a resolution of that.
Mr. Finlay, can I ask a question, Mr. Chair? Are you asking for the same right of the courts? Are you asking that following a hearing, a judge decides to consult others, and there are new policy considerations that are drawn to the judge's attention, which he hadn't considered prior to the consultation, that you should be accorded a similar right?
No, because, here's where I draw a real distinction. The analogy that what goes on in a judge's chambers or in the hallway of a group of judges' chambers is comparable to what is going on in policy-driven issues by specialized tribunals with respect is the difference between apples and oranges. I know what's going to happen when judges get together to talk about the case. I know the issues that are in play. I mean, that's the role of counsel. I mean, we know what the unarticulated major premises are that are going to be brought to bear. I don't when I'm dealing with a commission.
Well, I'm glad you know that, because some of us who have appeared before the courts wouldn't presume to know that.
Well,
And B, the issue is one of fairness. That's what we're talking about here.
Well, let me try you on a bit. I know I shouldn't, but what the hell. It seems to me that your question is a very good one for two reasons. One, it raises the difference, if there is any, between what we normally think of as law and what we normally think of as decision-making with respect to real issues in a so-called less defined area like the public interest. And I don't think those are clear distinctions by any means, but we work in a mythology where law has certain parameters and we think we're working within them. That's my first response. My second response to your question is different than Bryan's. I actually would expect that if a judge went out afterward and in the hall talked to one of his colleagues about a policy issue or an issue of law that hadn't been raised by the parties, and it would be determinative as to his decision, that it would be his duty to come back, invite the parties back, and ask them to make submissions on that issue. And I think that would be proper. And I don't think there's a clean distinction by any means. So, go ahead.
And can I just make a... No, I wasn't
Let
pointing...
Ron, go ahead. And then
No, I don't.
I'm pointing at you, Ron.
You know, I just wanted to make a plug for my taxonomy here. That if you're talking about issue agenda opinions that change, then I think both the courts and the agencies have an obligation to let the parties know that the agenda has changed and that there are other issues which have to be addressed. But if you are talking about what I called regulatory opinions or interpretation opinions that may change, then I don't think those are susceptible to the same demands from the litigants, in fairness.
Let me just exercise my prerogative once more, because this is a question for Ron, since he takes a strong line position. Do you not think that it would be preferable in an agency like with a large number of members to actually hold a rulemaking proceeding or a policy-making proceeding in advance or after a hearing, if what you're after is consistency, rather than holding an off-record meeting? Which would be preferable to you? And I say that because I think that alternative, apart from what I said this morning about rulemaking, arises very clearly out of Joan's presentation and the OSC's practice.
Well, I think our experience in our area is that rulemaking is fairly problematic, because what we find out is that our perspective on what the rule ought to be changes dramatically as we begin to get experience with particular cases and see the problem from the different perspectives that actual facts produce. So that the question of when you would do the rulemaking comes up. If you did it right off the bat when the legislation landed first on your desk, you'd get it wrong. And if you do it later, you've already had a number of cases. In fact, the policy development, the rulemaking that goes on in most agencies is done in the what Mr. Binnie has called the adjudicative mode. I don't think there is a reasonable dichotomy between policy making and adjudication. Adjudication is the policy making, and the opinions that are reached by adjudicators on regulatory matters and on interpretation matters and on application opinions become the tribunal's opinions, and as the decisions build, you develop your policy, and I'm really pessimistic about a rulemaking policy, rulemaking approach, certainly in our area. But I do agree that the party, we do publish our procedures, if I could say to Bryan. We have a draft decision review process that we put out in our annual report. And there are, of course, in any agency, there are all kinds of institutionalizing processes that are going on. You know, the selection process for your members to begin with, to get people who are compatible with your culture. The various things you do to develop a culture, an institutional culture that then has an influence on and the training that goes on, and the meetings to discuss current issues and developing issues in cases, not to decide them, but to raise people's awareness about the nature of them and so on. And then we've used leading cases in which we've gone out and asked interveners to share in a particular case that seems to present particularly interesting issues. We have a recent case where we realized after the draft was done that we had overstepped the issue agenda that had been operative in the hearings, and we sent the draft decision out to the parties and invited submissions directly from the parties and a group of interveners on the merits of that analysis in that draft decision. So there are all kinds. I mean, given some trust, there are all kinds of things that can be done. But it does seem to me that that you have to be able to think clearly, and as about exactly what it is that is needed and is happening. For example, this dichotomy between facts and policy, I agree, is impossible to draw, but it is not impossible to draw a line between findings and facts or policy. Findings which are tied to evidence are things you can recognize, in my view, and that's a useful dichotomy to draw.
There are a few more questions.
Just the policies, as the chair of the board that has held these kinds of discussions, and certainly while the board continues to exist and tends to continue to do so, the policy discussion may be nothing more than a distillation of the factors that the board will consider in reaching an opinion. I think that's important. It may not be the reaching of an opinion about anything more than the factors to be considered by the tribunal before it reaches its opinion on the facts of a case, number one. Number two, as Ron says, there are various ways in which the board can publicize its meeting at which this opinion is arrived at. For example, passing a rule, a guideline, which our board does, wherein it sets out those factors so that parties will know what the procedure is, know what the factors are that the board will consider in reaching its opinion on the facts of a particular case.
I'm inclined to say then, why do you need the meeting? But I won't. We've been through that. You had a question.
Let me answer that, because often, it's amazing how many more factors can be considered when one consults broadly, as opposed to thinking narrowly in terms of a particular issue as a result of a particular set of facts.
And are those factors made known to parties appearing before the board or your particular tribunal?
Well, in the event that a new factor was arrived at prior to the hearing, prior to a decision, but following the hearing, the answer is yes.
So that if I went to your tribunal, I could get a list of all the factors that the tribunal takes into consideration in coming to a decision?
Well, they're in the guidelines, that's what I'm saying.
Okay.
So that the determination, for example, as to when to hold a rehearing, what kind of factors the board would consider in making determinations about whether parties should be added, they are made public, they're in our guidelines. And often, the policy discussion is simply about that, about the factors to be considered by the board.
We're running over, but I'll take a few more questions if there are any.
I just wanted to have the panel's comments with respect to two aspects of consolidated Bathurst that hasn't been addressed in these. With respect to Mr. Binnie's comment about putting the onus on people to prove that something was wrong, I was under the impression that we do have a presumption of regularity in Canada, that we don't require judges along with their regions to issue a certificate that they were not bribed in reaching this decision, so that we can assume that we are supposed to assume that an agency will follow the rules of consolidated Bathurst. So I'd like to comment on that. The second one was, and it seems to be a view which has been repudiated completely by you, Philip, and by Bryan, which the Supreme Court was emphasized very strongly, which was that policy is not the exclusive preserve of the parties before this agency. That the policy, you have your shot at it. And I'm not simply talking about bringing in a new factor, that's quite different, but you have your shot at the policy, and once the groundwork is developed, once the rules are sort of laid out, the battleground has been joined, then it's the agency's social duty to develop this. And then once you get your shot, that is your shot. I just wanted, because this hasn't come up, and that's integral to the Supreme Court's decision.
Sorry. With regard to the first point, I thought we had addressed it with regard to the fact that I think, as I said, that with Connie Bathurst, there was a significant change. We are now dealing with the mixing of policy in these full board meetings outside of the presence of counsel. That, I think, is when you talk about the onus of regularity, you've gone really from one degree to another degree. And now it's important, because of that type of function that's taking place, that we do know what the process is. We can no longer presume that there's going to be regularity when we're dealing with that sort of sophisticated interplay. Sorry, your second point was the...
Who owns the policy?
Oh, there's no doubt about it. The tribunal owns the policy, but it's the application of the policy to the particular facts we're talking about. I'm not talking about getting into the policy-making function.
Let me pick up on the second one once more, and then I'll call it. It seems to me that what we're talking about is not whose responsibility it is to make the policy. That's clearly the tribunal's. It determines what the public interest is. The question is how it does it, and what the fairest way of its doing it is in terms of achieving a balance of its achieving consistency in determining the public interest and fairness to a litigant or a party or a respondent in a particular proceeding. And it seems to me that when those two intersect, all we're talking about is how you balance that out. There's no question that the tribunal makes a decision. It doesn't seem to me that that fact ends the matter. With that, I'll invite you to coffee, assuming there are no more questions, and thank the panelists very much for a lively discussion.